All right, I've got 102. Let's get going, guys.
Okay.
So you have questions about arbitration. So let me pose a question for you. If somebody buys a house and sometime after they moved in, it could be a week, it could be a month, it could be a year, they discover some latent defects. Those are defects that, uh, as you and I know, that if you have knowledge of them, you've got to disclose them. So let's assume that it was not disclosed and the homeowner discovers whatever that defect might be. What are the two remedies that the buyer, the new homeowner, has at his or her disposal? The first one is,
To arbitrate,
Arbitrate.
okay, arbitration. The second one is
not to arbitrate.
not to arbitrate,
Arbitrate.
also known as
Sue them.
lawsuit. Yeah, okay. So it would be a lawsuit. So the homeowner is faced with a choice of either contacting a lawyer and filing a lawsuit or going to arbitration. Why would they choose one over the other? I'm just trying to get a feeling for your knowledge of the processes.
I guess what I've been taught to say is, arbitration is typically cheaper and faster, although you can't appeal the decision. And that's kind of where it ends for me, I guess. I mean, there's a little bit more, but certainly read through that and talk to a professional, a lawyer, if you need more information.
Okay, you guys hit on it. If you file a lawsuit, you number one have to hire an attorney. Anybody know what the going rate these days is for an attorney?
Very
$350 an hour.
Yeah, it could be $300 to $400 per hour. So it can get very, very expensive. Plus, the court systems are quite busy these days, even with COVID. So getting onto the schedule of the docket at a courtroom could take months and months and months. So the alternative is arbitration. And arbitration, you can get done faster. And arbitration, you can get done for a whole lot less money. So from an economic standpoint and a time standpoint, the longer you drag something out, the worse it gets. The emotions go wild, the costs go wild. An arbitration decision is shorter, it's faster, and it's a whole lot less expensive. All right. So as you're explaining that to your clients, so which route do you want to go? Oh, one more thing that makes a distinction between going to court and arbitration. The maximum settlement, dollar settlement in arbitration is $15,000. So when you look at what the situation might be, is it worth going to court? It might be a larger settlement. Arbitration caps it at $15,000. All right. So that's all spelled out on your form.
And
so with that
is exactly what I was thinking, is that why then would anybody sign arbitration? Because if you find something latent, like a sewer line that needs to be replaced from the house to the street, and it's going to be a $30,000 ticket, you're stuck, right? If you signed arbitration, you're stuck.
Yeah. And the max you can get is 15. I don't know if a new sewer line would cost that much. I did one years ago and it cost me $1,500.
Oh,
okay.
So,
I think it depends on where. If you're in St. Paul on a rock bed, it's going to be a $22,000 fix, so.
It could very well be. Yep. And mine was maybe a 30-foot line or something. It wasn't all that complicated. So, Yeah, so those are the kinds of things, and it's always going to be kind of a crapshoot. You know, are you going to win? Are you going to get a settlement? You know, there are a lot of unknown factors. So those are some of the key differences. So now I'm just going to stop talking for a couple of minutes and just let you ask me your questions. Obviously, you've got issues that you're unclear about, and so let me see what I can do to help bring clarification.
I have a question, Jim.
Sure,
Um,
Christine.
and one of the things that I came across in when I was selling my last house, and we were in the midst of everything, the agent on the buyer side had not explained closing costs to them, and the buyers didn't have the money to close. We got lucky. They got a new quote out for their home insurance. We were able to close, so they reduced that. But because they didn't have the money to close, I was told like it could possibly be something where I'm like, would possibly have to arbitrate. And I just didn't understand all the details around why I would have to go to that place.
Oh boy. Let me back up.
Okay.
Were they going with a lender? Were they
Yes.
pre-approved with a lender?
Yes.
A good loan officer should always provide a cash to close estimate.
Mm-hmm. And this was not a good lender. It was horrible.
It was the buyer that, how did
Their
that?
lender was very difficult and did not give them a lot of good information in general. And the buyer's agent was also new, so he just didn't know and he didn't ask those questions. So like, I mean, I didn't know that they weren't doing like understanding those things until we got to this point. And he's like, well, the buyer's agent reached out and he said, we have an issue. And I'm like, okay.
All right. Kind of in the rules of engagement, I'm going to make a suggestion. You're going to hear me make suggestions off topic. As a listing agent, you always have the right to call the lender of that buyer to verify any and all information. All right. But a good loan officer should pre-approve credit, cash, employment before they even submit an offer. And you, as the listing agent, have the exclusive right to call that loan officer and say, "What's the story? Do they really?" I had one guy call me one time. He says, "Is this real cash? Is this really a cash offer, Jim?" And I said, "It's real cash. It's all green, sitting in the bank. She sold her house in California. It's burning a hole in her pocket." That won the deal, but he called and he verified. Since there was no loan, I did it the other day with somebody. So I said, "What's the story?" I'm protecting my seller clients. All right. So you always have that right. Well, if you look at the third paragraph down, starting with line 16 and going down to 21, all disputes about or relating to disclosure of material facts affecting the use or enjoyment of the property, excluding disputes related to title, are subject to arbitration under the arbitration agreement. Claims of fraud, misrepresentation, warranty, and negligence. So it includes those. So if there was fraud in any way, shape, or form on the behalf of the buyer, then arbitration would be in play. All right. But if it was just plain old screw up and somebody wasn't paying attention or somebody didn't do his or her job, you know, trying to go arbitration is going to be a little bit more challenging. All right. Did I answer your question?
Yeah.
Okay. Other questions? That was a good one.
Do you have your clients sign arbitration, Jim?
That depends on the price point. The last few properties that I've sold have been in the threes. And so, you know, chances of a very expensive dispute are kind of slim to none. So in those cases, yeah, but I always give them the choice. Always give them the choice. And if one party does not sign the arbitration agreement, you can't enforce arbitration. That includes the agents. So if
Oh.
we don't, or if the other agent doesn't, you don't have arbitration.
Why would we as agents choose not to sign if both parties did sign?
Could be any number of factors. It could be the type of property. It could be the nature of the parties. You know, you may look at them and say, this is going to be a very litigious transaction. Maybe the best thing for my client is to go to court. So it's kind of a judgment call at that point. It's going to depend on a lot of circumstances. Typically, if it's like a $500,000 property and above, I'll suggest to my clients, don't sign it. You know, because if there is a big issue and it's going to be a big dollar ticket, you may not want to be stuck or limited to 15,000. All right. So it's kind of a judgment call and just case by case. The newer the house, the lower the chances that something catastrophic is going to go on. Houses built in the 40s, 50s, 60s, 70s, 80s have got problems with windows, roofs, HVAC systems, basements that are bowing in, you know, just naturally have more problems with an older property. So it's just
So
kind of
if the
a
listing
judgment
side,
call.
if the
I'm
listing
sorry.
side doesn't sign it, then the buy side can't sign it either.
If one person doesn't sign it, everybody could sign it but one. And if one person doesn't sign it, there is no arbitration. Okay.
Got it.
So I
Them-
guess my question is, these days with sellers foregoing all kinds of contingencies, right? Inspection contingencies. Are we putting ourselves in a precarious position by saying, you know, if you don't have an inspector come in to, you know, look at the basement walls and, you know, stuff like that, are we doing our clients a disservice by either having them sign it or not having them sign it?
It's a good question. I would never, ever recommend to a buyer client of mine to not have an inspection. Even new
Right.
construction can have issues. All right. A builder could slip up. A subcontractor could make a mistake. The difference becomes, is it a condition of the contract or not? Now, you can have a home inspection for information purposes only, but it's not a contingency. So if you do discover something, you can't go back to the seller and say, fix this for me, please, because it's not a contingency. Um, it's a real sticky wicket because it is so competitive. I would still go with a home inspection contingency, especially with an older home, and just shorten the time period. That's what I have been doing. I have had all of my buyer clients have a home inspection and or a radon. You know, I don't want them to be at risk later. Now, if your buyer client says, you know, I don't want to make a contingent, you can either get them to sign, you know, print out something and you know, have them sign and say, I decline the home inspection contingency, or send them an email confirming our conversation today at 1:17 that you have decided to not make a home inspection contingent in your offer by 123 Main Street. Cover your backside. You declined it. I will confirm that in writing. If you don't, years ago when we were filling out contracts by hand, I would literally have them, I would write the word decline across the page and have them initial it or sign it, because I wanted to cover my backside that they were the ones who decided not to have the home inspection or to have it contingent upon a home inspection. Make sense? So all we can do is advise and counsel and suggest. They're the ones who have to make the final decision. But if something goes wrong, who they're gonna start pointing fingers at? Us. Because we have those deep pockets, you know?
Yeah.
Good question. Now, the other question I get is, well, do I go through the state association or Minneapolis Association for arbitration? And the answer is no. Down at the bottom of page 1 of the arbitration disclosure, matter of fact, it's line number 45, it gives you the website address. And bear with me while I share my screen with you. Oop, that's not it. Stop that share. Where'd it go? I had it all set up. Hold on. Let me move you guys down here for a second. Let me pull this up. Pull you back up. Still all there? Yep, there you are. There it is. This, and okay, where'd it go? There it is. This is the National Center for Dispute Settlement, NCDS. This is where you send your client. And when you scroll down, you'll see it's got Minnesota. And this will tell you everything about it. And here's their fee schedule. So the basic is about $250. That's cheaper than an attorney's 1 hour fee. So that's to file the arbitration. Both parties who would pay the $250. Generally, the winner gets that refunded. And you'll notice that it depends on the claims. It depends on whether there are 2 people or 3 people. And in the next one, it talks about the price of the home as well. So that's a fee schedule. That's not ours. It's not the Minneapolis Association. It's not the state association. This is this company that provides that service. Okay. And it's staffed by the arbitrators have backgrounds in law. A lot of them are retired attorneys, real estate, architecture, engineering, construction, or other related fields. So they do arbitration hearings for a number of different industries and types of clients. So ours would probably have a retired attorney or a retired judge who would then hear the case. Okay. Stop sharing, and we're back. You do have a time frame. So when you're talking to your buyer client, if they do wish to file, it has to be within 24 months of the date of the closing. That's on line 27. Within 24 months. So that's 2 years. So chances are whatever the defect is going to be, it's going to show up pretty early on. Okay. What other questions do you have? Those are kind of the highlights. Now, if somebody does file an arbitration, this does not preclude their ability to file an ethics complaint or to report somebody to the Department of Commerce. All right. So they're two just very separate issues. This is to go after the seller for items that were not properly disclosed or hidden defects of some kind. And the question becomes, well, are we held liable for detecting any material defects? No, that's not our job. That's why a buyer has a home inspector. And if there's something suspect about the plumbing, the heating, any of the systems, the roof, the foundation, they are advised to get a further inspection by a subject matter expert. The house that I put under contract this past week, there's a lot of dark staining on the underside of the roof in the attic. Is it mold? Don't know. But we've gone back to the seller to, actually, they even offered to do the testing, do the assessment, and if there's a problem, they're going to remediate it. That's a win-win. So my buyer did not feel comfortable moving into a house if there was possible mold up in the attic. They have 2 kids. Nope, we're not going to live in that house. So let's check it out. Let's get it fixed. All right. You've gone real quiet on me. You mean I answered all your questions? Golly day.
Have you ever had to deal with arbitration?
Hey, Jeff,
One time. Yeah.
can you enter into an arbitration later? Let's say, for instance, both parties to the transaction agree to do so, even though they may have declined on the arbitration?
If there's a case of fraud, maybe. And in a case like that, Rick, I would suggest getting counsel from an attorney. And if you need a good litigator, I've got the name of a bulldog. I mean, he sinks his teeth into a case and he does not let go until his client has, gotten resolution. So if you do, let me know. So the question was, was I involved in an arbitration? Yeah, it was years and years and years ago. It had a favorable ending for my client. He had his attorney present. So if you are in arbitration, you can bring, or your clients can bring attorneys. They can have legal representation. And my agent did, and he had his attorney there, and they won. So it's unnerving. Anytime you have to go before a panel of ethics, for an ethics hearing, or if you're getting called in by the Department of Commerce, or it's an arbitration, whether it's for a defect or an arbitration over commissions earned, it's very unnerving. And I have discovered over the years that the agent who has the best documentation, let me say that again, the best, most thorough set of written documentation usually wins. So I don't know about you guys, but my files sometimes get kind of thick because I document everything with emails, with text messages. It's my mother-in-law. She says, "Why am I a doorbell going doing, doing?" I said, "Well, think about it." I love her dearly. So anyway.
So if I understand Rick's question right, so if they decline arbitration and down the road they find something, then at that time, can the buyer and the seller go to arbitration, or must they litigate?
In a situation like that, I'm thinking they're going to have to litigate because they didn't agree to arbitration in the very beginning. So to kind of reverse it, I think it's that train has passed you by. So you're going to have to seek legal counsel and then do it the hard way, the expensive way.
Mhm.
All right. It's a litigious world, and it's easier to just do it right the first time. Disclose what you know. If a client tells you don't share that, the answer is no, I have to share it. Now that you told me, you'd made me aware of it, I've got to disclose that. Don't ask me to hide it. I've got to disclose it. And you can't disclose it either. I mean, you can't hide it either. You have to disclose it. So it's a lot cheaper than being in realtor jail. I hate bailing people out of that. All right. Good questions. Anything else? All right. Somebody else had a question about sellers' estimated nets, which is something that every seller should have in order to help make a decision to sell a property. Sellers work by what are they going to walk away with, their net. What do buyers base their decisions on besides sales price?
What
Isn't
their
it the
payment's
monthly?
gonna be.
Yeah, their monthly payment. So it almost seems like they're contradictory, but one is important to one is important to the other. So buyers work on monthly costs and sellers work on net proceeds. And I have to admit to you, I do not calculate this myself. I have a relationship with a title officer, and I will give her all of the information. And generally within 5 minutes, she is back to me with a printed estimate of what the seller is going to walk away with. I don't do it myself. There are too many variables. Now, it's real easy when you look at, and this, by the way, is under the Keller Williams Instanet Forms tab. So it's the very last document of that list. So it's real easy to figure out the sales price. And the seller should have a pretty good idea of what the mortgage balance is, or mortgage balances. It could be 2, it could be 3, it could even be 4 loans on the property. And you have to add them all up and subtract that from the sales price. The next 2 big items that we subtract are commissions. Ours should be 3.3% listing side, 2.7% selling side. Broker admin, whatever you are charging, the minimum for the office is $375. So if you're charging $400, you're pocketing $25. Use that for your marketing expenses. Then there are going to be other closing costs. The title company is going to run a search. They're going to have title insurance if you're working with a buyer, but if the seller is picking up part of their closing costs, you've got to know what some of the breakdowns are. So there are going to be closing fees. There's going to be a state deed tax. So on a $505,000 property, the state deed tax for Hennepin County is $3.40 per 1,000 and the recording. So it's going to be over $1,700 that the seller is going to have to pay there. They may or may not have been current on their property taxes. So if they paid in advance, they're going to get a credit. If they haven't and they're in arrears, they're going to have to pay that and get caught up. There's a conservation fee of $5. Water fees, if you're in a municipality where they're not on well and septic, but on public water, an outstanding water bill can be a lien placed on the property. And so the title companies are going to search for outstanding water bills to make sure that the new buyer doesn't get hit with a lien because the seller didn't pay their water bill. So that's got to be paid off. There might be a homeowner's warranty that the seller is providing for the buyer. So that gets deducted. So you add up all of those costs and subtract it from sales price, and that should be the approximate net to the seller. But again, because of all the nuances, I just have my title person do it for me, and I print it out. She sends it to me in email format. I print it out, and I have them initial it. That I discussed it with them. And like I said, she can turn it around in 5 minutes for me. She's that good. So that's why having good team members working with you, loan officer, title, home inspector, and anybody else that's a part of your transaction, make them a part of your team. And the more business you give them, the greater they're going to be responding. Mike, I need you to do an inspection this weekend. Okay, I can do it Saturday morning. Perfect. Becky, I need a seller's net by 3 o'clock this afternoon. I'll get it to you in the next 10 minutes. So those are great relationships to have. All right. Any other questions about seller's net? It should come pretty close to the Alta when you do get the Alta prior to closing. You know, there are always going to be a few differences with some of the prorations, but they should be pretty darn close. Obviously, if you've got a 2-month closing, they're going to be making 2 more months of mortgage payments. So that's going to change. And sometimes they don't know what their balance is, or the fact that they've got a line of credit. Oh, I didn't think that was a mortgage. Yeah. It's a $50,000 line that's sitting out there. That's a mortgage. That's a lien. You got to pay it off. Oh, sorry. I love dealing with the public. Someday I'm going to write a book. It's just real estate stories. Unbelievable. All right. What else, guys? I'm here to help you. I had a question this morning about an underground oil tank. Everybody familiar with what those are? Many years ago, you either put it in the oil tank in the basement of your house, or you put it outside and you buried it. Well, over time, they will disintegrate, they will erode. And unfortunately, there are cases where the fuel oil has seeped into the ground, contaminated it. So it's not only the cost of hauling that tank out, but it's also removing all that contaminated soil. So that could run you many thousands and thousands of dollars. So when you're talking to a seller client, ask if they've got an underground fuel tank. And if they do have one, they need to disclose it. And that happens to be on the seller property disclosure under environmental concerns. So it's right on there. So it's either yes or no. And if you need to explain a little bit more, there's a line right after it. So it's always disclose, 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 disclose. And when in doubt, disclose some more. And just make sure that everybody knows about it. I wrote an offer not too long ago, and up in the supplements was the seller property disclosure from when the current sellers bought the property. So it was like 3 years prior, 4 years prior. I included it, and instead of having the buyer, my buyer client, sign it, I just had them initial it, that they were made aware of that. If the listing agent took the time to load it into supplements and somebody wanted something disclosed, I was going to include that. So all I had them do was just initial it electronically, of course. All right. So just disclose, disclose, disclose.
So Jim, as we're talking about disclosures, today I was looking at a property that had a specific methamphetamine disclosure on the property. It has been on the market for 21 days, and I have not seen outside of the regular seller's disclosure, that specific disclosure for methamphetamine, it made me a little suspect, even though it said that the seller had no awareness of any methamphetamines on the property. Does that sound a little suspect to you?
Oh, boy, there could be a whole lot of factors surrounding that. Maybe they're in a neighborhood where there have been some problems. Maybe
Shasta?
maybe there was some history in that house.
Maybe.
So if in doubt, what should you do? Check it out. I would discuss it with my client and say, what do you want to do?
Mhm.
Do you want to have it investigated a little bit further? Maybe there's nothing to it, but do you want to take that risk? And especially if there are young children in the family, you know, do you want to take that risk? So I would probably err on the caution side of being cautious and just suggesting that they check it out. Now, it's always their final decision. And if they decline it, I will confirm that. Declined.
Hi, Leanne. Hi.
Hey, Carla,
I
you're live.
just got an email from her as well. Yeah.
Oh, Carla, you're live.
Okay.
Okay. While we listen to our
Yep.
conversation, is there anything else that you guys
I have a question.
No worries.
sure, Alex?
I don't know how much this relates to property disclosure or anything like that. It doesn't really, but so I had a client who wants me to help him
So let
buy
me,
a
I
lake
called
lot.
her and it was kind of
And
interesting. I left her a voice message because a lot of times
specifically
she
wants to use
clients that are doing selections and such. So I know she'll call me back today
Carla?
before she leaves.
Carla
But
Haley.
let's talk about, so are any of the lots that we talked about,
Can you mute her?
does that change your perspective at
Yeah,
all?
can
Or
you
are we
mute
still
her?
locked in on that? And then if
Carla,
you open up on phase 3, is there anything that are bordering? Like, for example, it looks
Let me
like
see if I can mute
Father's
her.
Song, there's a couple along the edges there, or even Pearl Drive, there's one on the corner. Yeah,
I don't know how to mute her.
okay. Yep.
Sorry about that, Alex.
So my question was,
Yep.
so he specifically wants me to represent him as a buyer for a
Then you
blank
look
lot.
at lot 5, then you look at lot 3. Have you?
Does anyone
so
have
the-
her number?
Is
Can you
that we would
text her?
want to go out and walk these lots if you haven't already, because,
I'm looking it
Okay.
up now.
I'll text her
Yep, I've
really
got it
quick.
up.
She's got her
Yep.
phone on her ear, so who knows? Call Carla Haley.
Yep, got it.
Did you mean Carla Haley? Calling now.
Okay.
Hey, Jim,
I just told her, I said, please mute.
if you go under the more,
Is
like where
that
the
a what?
dots are, you should be able to mute her. Like if you
No,
go to
it's not a
more,
corner because 7 and 8, which kind
You
of
go to
abuts, so you're gonna have
participants, I
somebody's
think.
backyard
All right,
then
I've got
facing
right
the
next-
side of where your,
participants,
probably your
I have
garage
chat, I
is.
have
So
participants.
what we would want to do is
I've got all
go
the
in and
participants
look
up.
at these lots and the model that you
And
Click on
want.
Say, or-
participants, you should be able to mute her.
Oh, hold on
That's
a
what I thought
second.
too, but it's not muted. Ah, there it is. Oh,
there it goes.
You've done
There
it.
we go.
okay. She's muted. She's gone.
That's it.
All right. All right, Alex, I'm sorry. Go ahead.
No, it's okay.
We're on to
So I have a client who specifically wants me to represent him for buying a vacant lot, lake lot. And he has another agent that's a family member that he was going to use to, if he decides to buy a house. He was very particular about doing it this way. So how should I go about writing the representation agreement if he is looking for a tear down? Because I don't know how to decide the difference between a tear down and an existing home. Like I don't want to, is that making sense kind of? I don't know how to approach this at all.
Yeah, and this is where you have that conversation with him. If he wants his family member to show him other properties that all he can do is, you know, move into, that's how they should write their buyer agency agreement. your buyer agency agreement should read something to the effect that you are being hired to find vacant land or tear down properties only.
Okay. All right, cool. That makes perfect sense. Thank you.
And we can always adjust with timing, you know, so it could be for just 1 week, it could be for 1 year, it could be for 6 months. But those are the only types of properties that you're going to be showing him, and make sure that he has a clear understanding with his family relative who's also an agent.
Okay. Thank you. Yeah, I guess I didn't want to infringe on if it's already a home that's there. I didn't want that to be part of his agreement. But yeah, that makes sense. Thank you very much.
Yeah. Okay. All right. Anything else, guys? We've been together 43 minutes. So I appreciate your time, your questions, and you know that if you call me, I answer the phone. And if I'm on another call, I call you right back. So, you know, don't think that even at 9 o'clock on a Saturday night that I'm not going to answer. I will, because that's my promise, my commitment to every single person in the office, including you, to answer your questions and to guide you through the minefield. And there are a lot of hidden minefields. So,
Well, thank
like,
you for this clarification on the arbitration. That was helpful. I appreciate it.
okay, well, you're welcome. You're
Yeah,
welcome.
thank you.
All right, guys.
Yeah, thanks, Jim.
I appreciate it.
You have a
Jim.
great one. Stay safe.
You.
Yeah, you too.
All right, bye now.
Bye.